Hello aspirants, welcome to Ekam Academy. Today, as part of the concept of the day series, we are going to discuss about an important topic which always appears in news, that is anti-defection law from polity point of view. So let us discuss what is this concept of anti-defection and what are the constitutional provisions you need to know from examination perspective. So what is defection? Defection means when you change your loyalty. That means if you are elected on one party ticket and if you generally shift your party after election, then it is called defection. To curb defections. Why we need to curb defections? Because we have to be responsible to the people who have elected us. At the same time, loyalty towards one's party is also very much important in preserving the democratic interest of that particular party. So to ensure all these things along with integrity, there is one concept of anti-defection law that was brought in Indian Constitution by 52nd Constitutional Amendment in the year 1985. So this was mainly brought during Rajiv Gandhi government's tenure, especially to solve the issue of Ayaram and Gayaram. So in one instance, famous person, one of the elected representative, so he has changed almost 4 parties in one day based on the best offer that he got from the political party in terms of contesting elections. So that is what the nature of politics that we are having today, right? So I'm not criticizing anyone, but still this is a level of politics that we are seeing in the present situation. So all these are reflecting that there is no electoral mandate that is being upheld by the candidates in most of the situations. To prevent this thing, we have an important act that was brought in Indian Parliament by constitutional amendment in the name Anti-Defection Law. So in this particular law, what is the main thing? So to stop defections, that means shifting loyalties of the parties from one to another by the candidates who already got elected. That is the main objective. So first let us understand what will be the provisions. For example, if any person who have contested as an independent candidate, right, without any party support, he has contested on his own independently and he has won the election. Then after his election, if he joins any political party, then that can be a ground for defection. Second, if any nominated person, we know in Lok Sabha there can be 2 nominations, right, from the Anglo-Indian community. Now that was not there. At the same time in Rajya Sabha, 12 nominated persons can be nominated by the President of India to Rajya Sabha. So in case if those persons join any political party, the most important thing is after 6 months. That means within 6 months of their nomination, if they join any political party, then disqualification on the grounds of defection will not be attracted. But then if any political party or if any representative votes in contrary or abstains voting in contrary to the decision of the political party. That means if political party has given a stand in respect of one particular decision in the parliament or the state legislature, to contrary if he has acted upon, or without the permission of the political party, if he was abstained from voting without prior permission, that can also be a ground for defection. Then finally, if any particular party person give up membership, right, give up membership voluntarily of that particular party and joins another party voluntarily also, if we give up membership of that particular party and join any other party, on these grounds generally defection can be imposed. So who will be the deciding officer? Speaker or chairman. Speaker in the case of Lok Sabha and chairman in the case of Rajya Sabha will be the deciding officers or the persons. Then what is the article associated? Article 102 clause 2 talks about defection in the grounds of disqualification on the grounds of defection. Any person or any representative who was disqualified on the grounds of defection also stands disqualified as a minister, right? So this is all what you have to understand. Then what are the exceptions granted? So exceptions granted are in case of a merger, right? So merger means when more than 2/3 of the members of one political party join another political party, then that does not qualify as a defection for disqualification. Then second ground is when the speaker, right? Speaker is also a member of Lok Sabha, right? So when he was a member of Lok Sabha and he has to take the position of a speaker who has to generally be neutral, then he can also voluntarily resign. Although it was not a mandate, he can voluntarily resign to maintain his neutrality. So in that situation, when he gives up his membership voluntarily, but still it is mainly to uphold his duty as a speaker, then it will be exempted from the ground of disqualification on the grounds of defection. So these are the two exceptions granted. But earlier, before this 91st amendment that was brought in 2003, even the ground of split means 1/3 of the members. Understand? If 1/3 of the members generally split from one political party, and if they join another political party, it should not be a ground for defection before 91st amendment. But later, this amendment has also included a provision when if there is a split and 1/3 of the members join another political party, then it attracts the ground of disqualification on the grounds of defection. Then what are the important cases, right? So we have to remember here about Kehoto Holohan versus Jachilo case of 1992. So what is this famous case? So in this particular case, Supreme Court has held the speaker's decision in case of defection related to defection related cases will be final, but it can be subjected to judicial review. So judicial review will also be there. At the same time, same thing, Ravi Nayak versus Union of India case. So in 1995, so this case also has re-emphasized the role or the power in the speaker and chairman to decide disqualification on the grounds of defection, right? But still, there are many recommendations that most of the time speakers who generally belong to the majority of the ruling party doesn't take a call on defection related cases, and they generally they will lapse the time. So because of this, many recommendations were made that there should be a neutral board, or sometimes judiciary should take a proactive role in deciding the cases, or there should be like a tribunal type of thing which will decide what will be the ground of defection or who has to be disqualified, these things. But still recommendations are not yet implemented. So let us see the practice question on this regard. So which one of the following schedules of Indian Constitution deals with anti-defection? So try to choose the correct answer and let me know in the comment section. Today, so as part of the concept of the day series, we have discussed about anti-defection, what are the constitutional provisions, and what will be the grounds for defection, who will be the deciding authority, and related exceptions. So this is all with respect to today's video. If you like the video and found informative, let us know in the comment section. Thanks for joining. All the very best.